Hi and welcome to EBA4063 Specialized Taxation. We are going to present on the tax case study number 4. So this presentation is prepared by Daine Esther, BEATRICIA, Muhammad RIDHMAN, NURUL AZEAN, and NURUL RABIATUL. So this case tax study is about the Genting Malaysia decision on the protection of personal data from tax authority. These are our group members, starting off with Daine Esther, BEATRICIA, Muhammad RIDHMAN, NURUL AZEAN, and NURUL RABIATUL.
Hi, this is Muhammad RIDHMAN, and I will be presenting on the introduction. Under the Income Tax Act 1967, the Inland Revenue Board (IRB) has broad powers and tools to ensure effective collection of tax revenue for the Malaysian government. This includes wide information gathering powers such as those provided for under Section 81 of the ITA, which empowers the Director General of the IRB to demand any person to disclose any information or particulars that is in possession or control of the person for the purposes of the ITA. The scope of DGIR powers to request information was recently tested in the case of Genting Malaysia Berhad against Personal Data Protection Commissioners and ORS, where the DGIR relied on the Section 81 of the ITA to make a blanket demand for customers' personal data from Genting Malaysia Berhad. The High Court, in its decision, ruled in favor of GMB and held that the Personal Data Protection Act 2010 PDPA does not allow the DGIR to make such demand in views of the protection afforded to individuals by the PDPA over their personal data. Therefore, this presentation seeks to provide a summary and brief analysis of this case and examine the potential impact of the High Court decision on organizations carrying out personal data processing activities under the PDPA.
Hi, my name is Daine Esther and I'll be presenting on the main points. So, about this tax case study is a dispute between the Genting Malaysia Berhad against the Director General Inland Revenue. So we start off with the issue. This tax case study is a conflict regarding the protection of personal data by the Personal Data Protection Act 2010 and the powers allowed to the tax authority in obtaining the personal data stated under the Income Tax Act 1967. So this case study is about the Director General requested disclosure of the Genting Malaysia's client's personal information that has a transaction value above threshold without specific purpose and was later refused by the Genting Malaysia as it did not comply with the Personal Data Protection Act. So we have come to a conclusion whether the DGIR has the power to demand such information from Genting Malaysia about their client's detail without any reasonable intention.
Hi, my name is BEATRICIA and I will present on the rules of the case. The scope of DGIR's power to request information was recently tested in the case of Genting Malaysia Berhad against Personal Data Protection Commissioner and ORS, where the DGIR relied on Section 81 of ITA to make a blanket request for all customer data from Genting Malaysia Berhad. This section gives the IRB's Director General the authority to seek the disclosure of any information or particulars in a person's possession or control for the purpose of the ITA. Failure to comply to this section will be penalized by a fine of not less than 200 ringgit and not more than 20,000 ringgit or by imprisonment for not more than 6 months or both. Next is Section 8 of PDPA. When processing personal data users like GMB are expected to follow the 7 Personal Data Protection Principle, including the Disclosure Principle under Section 8 of the PDPA. As a general rule, under the disclosure principle, data user, i.e. GMB, are prohibited from disclosing personal information about individuals to third parties without first getting their first consent. However, this general rule is subject to certain exceptions provided under the PDPA, which include Section 39B1 and 2 and Section 45(2)(a)(3). This section essentially allows the disclosure of the personal data of individuals without their consent if the disclosure is, according to Section 39B1, necessary for the purpose of prevention or detection of crime or for the purpose of investigation. According to Section 39B2, required or authorized by or under any law, i.e. Section 81 of the ITA. And lastly, according to Section 45(2)(a)(3, for the purpose of assessment or collection of any tax or duty or any other imposition of a similar nature. That's all for the rules, and we'll move to the next part, which is analysis. Thank you.
Hi, my name is NURUL as in IZZAH, and I will explain about the analysis parts of this whole case. So, on 27th of July 2021, the High Court ruled in favor of Genting Malaysia Berhad and held that the PDPA disallowed the DJIR to make such demands given the PDPA's protection of people personal data. For that, the Commissioner, Deputy Commissioner and DJIR have all filed appeals to the Court of Appeal against the High Court's ruling as of the date of this update. Therefore, this matter at that time is pending before the Court of Appeal. But, pursuant to the recent issuance of the High Court's full grounds of judgment, this update seeks to provide a summary and brief analysis of the High Court's findings, which will be further explained on the next slide. So, as mentioned by BEATRICIA earlier, the rules that involved in this case include Section 81 of ITA and also Section 39 and Section 45 of PDPA. So, the first one I will explain for under Section 81 of ITA. The High Court ruled that Section 81 of the ITA does not permit the DJIR to make such comprehensive demands for personal data, and authorizing such blanket disclosure of personal data would involve an infringement of the PDPA's provisions. Other than that, the court also decided that the DJIR cannot require Genting Malaysia Berhad to reveal its customers' personal information under Section 81 of the ITA unless and until first, the DJIR get GMB's customers' agreement to the publication of their personal information. The second one, the DJIR can show that there is a reasonable indications that any specific identified or identifiable customer has violated any provision of the ITA relating to the assessment or collection of tax, warranting the disclosure of the customer's personal data. Or the last one, the DJIR obtains a court order authorizing the demand for personal data disclosure. Next, I will explain for under Section 39 and 45 of PDPA, which are the exceptions. So for this case, the High Court held that under the exceptions provided in Sections 39B and 45(2)(a)(3 of the PDPA, this group of personal data cannot be disclosed to third parties unless, first, both the disclosing party, which is Genting Malaysia Berhad, and the requesting party, DJIR, have obtained a final court order from the court of that jurisdiction authorizing the disclosure of the personal data. The second one, the disclosure exemption under Section 39 of the PDPA is optional, and the data user has the right to reveal personal data under Section 39 of the PDPA. And last but not least, the PDPA Section 45 exemption only applies to personal data processed by the data user for the reasons mentioned in Section 45 of the PDPA. So that is all for my parts. Next, I will pass to RABIATUL for the conclusion.
Hi, I am RABIATUL. To conclude, the dispute between both parties, Genting Malaysia Berhad against the Director General Inland Revenue, has been resolved, that require DJIR's demand being rejected by the High Court in accordance to Section 81 of the ITA, Section 39B and also Section 45(a)(3. DGIR has no right to demand for Genting Malaysia Berhad to reveal their customers' personal information unless it is in fulfillment of few conditions stated in Section 81 of the IDA, which includes customers' agreements to the publication of personal information, or DGIR can show that there is a reasonable indications that customer has violated any provision of the IDA, or the DGIR obtains a court order authorizing the demand for personal data disclosure. This indicates that the laws is always being upgraded to protect the disclosure of personal data, such as limiting the right for the request of revelation.
So this is our references, and thank you for listening to our presentation.